very much, Katarzyna. Thank you very much, dear colleagues, for being still with us here. If I wanted to save us some time and to enable us to go to dinner as soon as possible, then I could summarize this by saying that there are no legal rules when it comes to the use of AI in the defense and military domains, at least as the legislation and the state of law stands currently. But if we are speaking about some challenges which might inhibit the development of AI for defense and military purposes, then there is some very limited legal ground to cover. So if you allow me, in the next 20 minutes, I would be speaking mostly about those issues. So basically, we are speculating here a little bit, but we are trying to look into the future, and we are trying to look at some legal challenges which might be impacting the ability of mostly European countries to develop and to use the AI in military and defense purposes domains successfully. Also, I want to start with some quotes, and I think that our colleague Sorel, however we pronounce this, would be very proud, because it is me and this talk who, without any coordination, decided to use the same quote. So obviously the colleague from the UK said something remarkable. And she did say, when she was describing the European landscape, political and legal one, in the domain of AI, that European states exhibit self-imposed ethical and legal restraints, which are bordering on cultural technological conservatism. And it is not just she. So also, when we are looking at French defense AI strategy from 2019, if I'm not mistaken, but I might be mistaken, then France is also describing Europe, when it is analyzing different powers in the world, as an inspiring intermediate power whose hardline approach to legal and ethical issues may be a strength or a weakness, depending on the impact. So if it turns out good, then it is a strength, but if it turns out bad, then it is a weakness. So obviously there is something about us Europeans that the others, but also ourselves, that we consider ourselves as sort of focused and obsessed with ethical and legal constraints. For ethical ones, I agree completely, but I think that others have spoken more eloquently and better than I can do on those issues. And of course, there are a lot of ethical challenges. But what is really going on with legal challenges? So let's try to figure it out. As this talk and others have been saying, the upcoming AI Act, which was sort of finalized in December 2023 and is now waiting to be voted on, is going to regulate the use of AI among the member states of the European Union. It was first prepared in 2021. It underwent some changes, and different versions have been made available. And once, when it becomes enacted, it will be the first global regulation of the AI. So nothing comparable to this act we can find in other countries in the world. Looking at what we have currently, we have as it is nowadays very frequent with European Union legislation, we are having a sort of risk-based approach in which different systems are characterized in different categories. We have, in the context of AI, some systems which are considered so intrusive and so serious in risks that they are prohibited. Then we have some high-risk systems, some moderate-risk systems, and of course there is some AI for which no significant risks have been identified. And the AI Act attempts to cover them all. But what we are also seeing is also what Istok mentioned, is that there is a very clear consensus among the member states of the European Union that this legislation should not be applicable to the military and defense domains. And I will go very briefly through this, but it is important to note that actually the thinking of European countries is getting more refined when we are speaking about this exception. So if we are looking at the first version of the AI Act, which was published in early 2021, it said very simply that the regulation shall not be applicable to systems developed or used exclusively for military purposes. 6 months later, during the Slovenian presidency, this was further elaborated, and now it was mentioned that it will not be applicable to systems used or developed exclusively for military or national security purposes. So the national security was also added in this exception. Now, in the current version, and I'm I will not say ashamed, but not very happy to say that I'm quoting from something which was leaked online and which is not made officially to the European public. Now we have a very detailed provision which says in 3 paragraphs mostly the same thing, but also some additional elements are being introduced here. So in the first paragraph, basically the European legislator, I would say under the pressure from the member states, is trying to say that this act in no way changes the distribution of competences between the Union and its member states. So it is making specific references to the Treaty on the European Union and stipulating that defense and military are the domains of core state competences, hence no regulation should be applicable in this context. But then when we look at the second paragraph, what is excluded is systems used exclusively for military, defense or national security purposes, with additional element added, and this is regardless of the type of entity carrying out these activities. And it appears that the thinking behind this newly added element is that it also covers private and public entities. So it would not be just that the military AI is being excluded when it is being used by the military forces, but also in certain cases, certain private actors, when they are acting in this domain, would also be covered by this exception. And the third paragraph further clarifies that this applies to AI systems which are being put on the market in the European Union or which are being applied or used without being officially put on the market. So I think there are very good reasons for, maybe you can say, a little bit of paranoia among the member states in defining their competencies and shielding their national sovereignty from the competencies of the European Union. And some of the things that I will be saying very shortly might illustrate the thinking behind this. But what this us leaves with? So when we are speaking about legal challenges and we are speaking about legal constraints to the use of military and AI in the European Union, so basically what are the concerns? Because I don't see any. When this act comes to force, it will, at least in my understanding of things, it will not impact the use of AI significantly. The use of AI. Situation might be different when we are speaking about the development of AI and specifically with regard to dual-use things, dual-use systems, which both of my colleagues have been speaking extensively about. So to summarize a complicated story a little bit, I think, or at least it appears to me, that when we are speaking about lethal weapon systems or other AI systems which can be used exclusively for military and defense purposes, no legal constraints will be relevant. And they will also not be relevant in the development phase. But for some dual-use, high-risk AI systems, which include what Istok was mentioning, the example of autonomous car and the technology being applied to drive the tank autonomously later on, development of technologies such as this one will be to some extent covered by the AI Act. Whether this is good or a bad thing, we can debate upon. Of course, if there is any regulation, then the environment for development is more constrained than when there is no regulation. But of course, I mean, we also want to develop civilian AI responsibly, and we want to ensure its safety. So there are benefits on both sides here. The same goes for general purpose AI and also for the generative AI. It would theoretically impact the ability to develop certain content, but for instance, if European states would decide to do the fake videos and to use them for military purposes in some sort of offensive action, once again, this would not be covered by the AI Act, so I don't feel there is a lot of regulation here. So if this is the thing, so where is the challenge? Because I don't see it in the AI Act. Maybe I'm wrong, and if I'm wrong, I would be very happy to hear your opinion on this. You can correct me if you want, but I don't see that this is such a problem. The problem might, at least in my opinion, be in another domain. So when we are looking at the AI, and please do not ask me to define it, because I cannot define it. When we are speaking about AI, what comes to my mind is the statement made by a very famous Croatian singer, Mate Mišukovac, who once remarked that nobody is a stylist anymore. Nobody is a tailor anymore. They are all stylists now. And I think that the same goes for the AI. Nobody is a software engineer anymore. They are all AI developers right now. So we do not know what AI is, but maybe we can recognize the AI when we see it. But to come back to my point, when we are speaking about AI, at least in my very simplistic legal perspective, we are speaking about some technology which is being used to process some data. So let's see what might be happening on the data part. Once again, reading from the French defense AI strategy, they are a little bit obsessed with data, and I would say for a very good reason. So for instance, in France, they consider that major digital players, especially American and Chinese, have access to what really fuels the AI, and it is the data. It is the data of millions of citizens of all the countries around the world, and effectively they are using this data, which is provided to them voluntarily, to develop different sorts of applications and to develop their AI successfully. So, let's come back maybe to this point. How is data regulated in the European Union? Because there is a lot of regulation here. So let's make a difference, very basic one, between the non-personal data and personal data. I think, at least in my opinion, that if there are any challenges, I think that they are here. When we are speaking about non-personal data, then it is regulated to some extent on the level of the European Union, but it would not be very demanding, and it would not be very limiting to use the non-personal data in the military and defense domains on the basis of these rules. So basically they are just impose certain requirements such as prohibition of data localization. There are some self-regulatory codes for data portability, but other than that, this regulation does not go. So basically there are some rules there, but once again, they are not very challenging. But once we turn to the personal data protection, then we of course know who is the main player here, and it is the General Data Protection Regulation generally, and also we have the Law Enforcement Directive for the processing of personal data in the law enforcement context. And when we see what these rules are doing, then they might be very challenging and very strict indeed. So at least in my very brief explanation, we have the purpose limitation principle, which limits the ability of different actors to use data which is existing for secondary purposes. So basically, if something is used for one purpose, then it couldn't be very easily used for other purposes, including in military and defense domains. Also, in Europe, we are requiring that every data processing is having an appropriate legal basis. This is not something which you will find in many jurisdictions around the world. We have very strict limitations regarding data sharing. We are seeing personal data as something which is part of the fundamental human rights of citizens, and therefore it is very strongly enforced. And finally, we are having very strong public attitudes about personal data protection. So the European citizens actually care about their personal data, and we have seen in some countries that, for instance, when some AI systems are being developed or being used, very frequently there is a public outcry against these attempts. So if we are to find some challenges and some potential impact, I think that it might be here. Of course, we might be saying the following. Do we really care about personal data protection rules when we are speaking about the use of AI in military and defense context? Because if we are in the state of war, I think that we can agree on that that state would actually trump a lot of fundamental human rights, including the right to personal data protection. Well, this might be the case for the situations in which combat is taking place, but as Istok was explaining, there are a lot of applications of the AI which are happening also outside the context of the pure combat. And therefore, there is a lot of possibility of dealing with personal data protection rules as well. Also, we can see that some international organizations, such as NATO, are also making references to the personal data protection rules. So in the NATO data exploitation framework policy, NATO is arguing that, yeah, we need to share data, but we also need to do it in a way which is protecting personally identifiable information and privacy. And also in the French strategy, we have a small chapter on the importance of personal data protection in the context of military and defense policies. And basically the French government is also saying that when doing the military and defense AI, we need to comply with the personal data protection rules such as the ones in the General Data Protection Regulation. Both of these documents are misapplying the concept of personal data. Which is interesting to some extent, but basically at least some lip service is being paid to the personal data. So it's not that NATO is completely ignoring this thing. So I will not be speaking about definition of personal data very extensively. I can speak on this for 4 days. But basically, I think that if I asked all the people present here, and unless there is a huge expert on personal data protection here, I think that all of us would interpret this notion more narrowly than in reality it is. So basically, on proper implementation of European Union personal data protection rules, almost everything is personal data. So, for instance, Istok was speaking about data from different sensors or data which can be obtained from social networks or different types of metadata. If done properly, all of this will be considered personal data. And this is also confirmed in the jurisprudence. So the current position of the Court of Justice of the European Union about the notion of personal data is very broad, but it is getting broader daily. And actually this morning, the Court of Justice published another decision. I still didn't have the opportunity to read it because I was just notified on one of the blogs about it during the lunch. But it appears that it did broaden up the definition of personal data a bit more. So if we are doing it properly, everything will be personal data, and it will create certain limitations when we want to use those data for the purposes of military in defense and for the purposes in the military and defense. Okay, another thing that you might be thinking instinctively is, but do we really care about personal data protection rules when personal data is used for the military and defense, because that is outside the scope of the European Union legislation, in the same way that the AI Act should be outside the scope of the European Union legislation. And if this is your thinking, you would be correctly right, I would say, and you would be having a good knowledge of the Treaty of the European Union. But you would be also finding yourself in contradiction with the opinion of the Court of Justice of the European Union, who in one case, La Quadrature du Net and others, which was about law enforcement context, but also touched upon the issue of national security, decided to send a message that, yes, national security is a matter of exclusive competencies for the member states, but under certain cases, they are also going to scrutinize the legislation in that area. And it appears on the basis of this legislation, or on the basis of this case law, that actually the court is doing a difference, making a difference between those cases in which personal data is being processed by private entities, such as companies, NGOs, and so on, and on the other hand, those cases where personal data is being processed by the public authorities themselves. So if this view would prevail, and it is prevailing for now, this effectively means that if the military and defense industry wants to tap into data sources and data sets of the private entities, then this would be under the control of the European Union personal data protection legislation. So in this domain, are there any challenges? I think that this is where we might be finding some. So as I already mentioned, data sets which are held by privately held companies will be unavailable for data for national authorities, or at least they will be unavailable without additional legislation. So the member states will need to legislate in order to enable the use of personal data for the purposes of defense and military. And of course, this legislation is also subject to additional legal scrutiny, which can come in the form of national constitutional requirements, constitutional requirements under the European Convention of Human Rights, and also the control of the Court of Justice of the European Union under the Charter of Fundamental Rights of the EU. Secondly, under the current legal regime, it appears that it is very challenging to use existing data sets for new purposes, including to train and operate AI. Thirdly, it seems that generally it is very hard to reconcile operations of AI systems with personal data protection standards. And if, I don't know if we have some young researchers here, but if somebody would like to make a PhD thesis on this topic, I think that they would be finding it actually very, very fascinating. Fourthly, the national courts and the national regulators are also stepping up in the same way as the Court of Justice is doing it. And therefore, when we are speaking about application of personal data protection rules, it is, in my opinion, likely that we will also be seeing a lot of activities of those regulatory bodies and courts in the national security, defense, and military applications. And finally, what worries me maybe the most is that, at least in its current practice, the Court of Justice of the European Union did not shy from imposing its will when it comes to the processing of personal data in the national security domain, which is may be acceptable, but what is really problematic is that in doing so, they have really upset the delicate balance. And I think that without proper policy considerations, they have been actually creating too burdensome requirements for the member states when it comes to the law enforcement and investigations of serious criminal offenses. And I would dislike to see that also happening in the military and defense domains. So, Katarzyna, I think that I'm right on time. Thank you very much for your attention. I know that this is the last presentation of the day. So thank you very much once again. And if there are any questions, please, I'm here. Thank you.